All right, it is 1 o'clock, so we are going to go ahead and get started here. Hi everyone, thank you for coming or attending. This is Eric from hrsimple, and we're glad you're here today. We'd like to welcome Erin Schilling from Polsinelli. She's going to talk about VEVRA, the OFCCP, and federal contractors today, and some changes that we all need to be aware of. So we're really happy to have her. Erin authors the Kansas and Missouri Human Resources Manuals on hrsimple.com. She practices in both Missouri and Kansas for Polsinelli, but Polsinelli is also a nationwide law firm. So definitely check out Erin Schilling. She's going to give us a great presentation, but also check out Polsinelli as well. Erin, could you go ahead and just flip to the second slide for some quick announcements? Thank you. Today's presentation will last approximately 60 minutes with some extra time for Q&A at the end. hrsimple.com is an HRCI approved provider and a SHRM recertification provider. At the end of this webinar, we'll give you codes for both certifications to get your credits. Please enter your questions in the chat box and we'll address them when we can. A recording and slides will be emailed to everyone who registered and attended to this presentation. We're also posting all of our webinars at youtube.com/hrsimple, so check them out there if you want more good stuff. So yeah, we're just going to jump right in and turn things over to Erin, if you're ready, Erin.
All right, thank you, Eric. Okay, so we're going to first start off, and I'm just going to dive right in here and give you, this first slide has a couple of terms on it that we're going to be using a lot that I wanted to make sure everyone understood. First is the OFCCP, which stands for the Office of Federal Contractor Compliance Programs. This is a division of the Department of Labor that enforces the obligations that federal contractors have with regard to affirmative action. I also sometimes use the abbreviation IWD, which stands for Individuals with Disabilities. Okay, first off, I want to just kind of touch on the difference between equal opportunity and affirmative action. On the one hand, equal opportunity is treating all employees equally without regard to a protected characteristic. It means not discriminating against someone. It's passive in nature. In contrast, affirmative action is very active in nature. It's taking action to employ and advance individuals based on their protected characteristics. Federal contractors not only have the equal opportunity obligations that all employers have under Title VII, but they would also have affirmative action obligations. So these are the laws that we're going to spend most of today discussing. The first is Executive Order 11246, and sometimes I just abbreviate it in the slides with EO. This law prohibits discrimination and requires affirmative action with regard to several different protected categories: race, color, sex, religion, sexual orientation, gender identity, and national origin. And I went ahead and underlined sexual orientation and gender identity because those are newer additions to this executive order. Second, we have the Vietnam-era Veterans Readjustment Assistance Act, which is commonly referred to as VEVRA and sometimes referred to as Section 4212. This law requires government contractors to engage in affirmative action to employ and advance in employment qualified veterans. Finally, we're going to spend some time talking about Section 503 of the Rehabilitation Act, which I commonly refer to as Section 503. This law requires affirmative action to employ and advance in employment qualified individuals with disabilities. So when it comes to affirmative action, those requirements extend the full range of the employment spectrum. They start at the very beginning of the process, at the recruitment process, and extend all the way through termination. Much of the focus under this administration and in recent years, and in really for the laws in general, but there is definitely a renewed focus on this, and that's in the recruitment and the hire and selection process. So we will spend quite a bit of time today talking about those parts of the employment process. So who's covered? So who is a federal contractor? So first of all, you would be covered by these laws if you're doing business with the federal government directly. So if you're doing business with any agency of the federal government, you would be covered, assuming you meet the applicable dollar thresholds for that business. You could also be covered indirectly through doing business through a prime contractor. So let's say you're doing business with another company, and that other company happens to have a federal contract with the government. You could also be covered as what's called a subcontractor. And the laws apply the same, these affirmative action laws anyways, apply the same whether you're a prime contractor or a subcontractor. So when I use the term federal contractor, I'm referring to those terms collectively, both the prime contractor and the subcontractor. Now, there are different levels of requirements, and they begin at a very low level. So at just a contract of $10,000, you would have basic affirmative action coverage for women and minorities under the executive order. At $15,000, you'd have basic coverage for individuals with disabilities. And then at $50,000 is when some of the bigger requirements start. That's when you have to have an affirmative action plan. So when I use AAP on the slide, I'm referring to an affirmative action plan for women, minorities, and individuals with disabilities. So the plan requirements for each of those groups start with a contract of $50,000 or more and 50 employees. So if you're a small company and you have even a large contract, much larger than $50,000, you still don't have to have a plan. It's when you get to a 50 employee threshold. And then at a $150,000 contract, you'd have your basic coverage for veterans. And then if you have a contract of 150 plus 50 employees, you'd have an affirmative action plan requirement for veterans. Now, just a couple notes on the dollar threshold. So frequently, the federal government uses a contract vehicle referred to as an indefinite quantity contract. So the contract doesn't have a total dollar amount set. It might say that the government could purchase up to X amount of dollars, or it also might just say, we're going to pay X dollars per service. And that service individually is much lower than any of the dollar thresholds. So for example, let's say we're going to pay $1,000 for XYZ, but it doesn't say how many times they're going to purchase XYZ. And so the key there to evaluate whether you meet the threshold is not that the service costs $1,000. You need to evaluate whether at the time of the contract there's reason to believe it will or will not exceed the dollar threshold. So if when you enter into the contract, you have reason to believe that the contract's going to exceed that $50,000 threshold, then you would be covered for that affirmative action plan requirement for women, minorities, and individuals with disabilities. Also, I want to just make a note on aggregation. So for that $10,000 threshold, and only for the $10,000 threshold, smaller contracts can be aggregated together to reach that threshold. So for example, if you have a handful of small contracts, maybe you have 10 for $1,000, we'll just make it easy, those can be aggregated together to reach that $10,000 threshold. And that is where your basic coverage is triggered. Now, for the $50,000 threshold, there's a different, the aggregation does not apply at that number. So you have to have a single contract of $50,000 or more to reach that threshold. And that's the same for the $150 threshold as well. So the only time aggregation is accepted is for that $10,000 threshold. Okay, now let's just talk a little bit about what is a subcontract. So, this is a common question. So I could, my business could be doing business with lots of companies that possibly have federal contractors. I don't know if they do or not. How would I know if I'm a covered subcontractor? And I have up here on the screen the definition of a subcontract from the regulations. So in order to be a cover subcontractor and be covered by these affirmative action requirements, your business has to be doing something that's necessary to the performance of that prime federal contract. Or you have to be either performing, undertaking, or assuming the duties under that prime contract. So, for example, if the prime contract is to make widgets for the federal government and you are mowing the grass for that company, you're probably not doing anything that's necessary to the performance of that contract, and you're certainly not performing or undertaking or assuming any of the duties related to the widget contract. So you're not a subcontractor in that situation. So there needs to be some sort of tie between what you're doing and whether it's necessary to the performance of that federal contract. And if your business is one that's asking, am I a subcontractor, you often have to have a discussion with the prime contractor to talk about what the nature of their federal contracts. Sometimes a key that would tip you off that you might be a subcontractor is if that company puts what's called the EEO Clause in your contract with them. And we're going to talk more about the EEO Clause later in this, but it's the language in the contract that would talk about application of the laws that I mentioned, VEVRA, Executive Order 11246, Section 503, etc. Okay, so we're going to kind of switch gears just a little bit and talk about your affirmative action plan structure and some requirements related to that. So when do you have to do an affirmative action plan? So once you become a federal contractor, you're required to have a plan in place 120 days of the contract. That affirmative action plan, however, is not turned into the government, turned into the OFCCP or any other agency. It is, however, it could be reviewed, and you could be required to submit it if you're selected for what's called a compliance review, or what's also commonly referred to as an audit. So an OFCCP audit or an OFCCP compliance review, those mean the same things. If you are selected for audit, then you would have to turn in the plan, and you'd have to provide a whole host of supporting documentation for that plan. In short, you put the plan in place every year, any 12-month period. So you can pick the calendar year, you can pick any 12-month cycle at any point in the year. Some companies choose the calendar year. Many companies do choose the calendar year, but others would choose maybe their fiscal year, or they might choose just a different 12-month period that might work well for their organization. Perhaps there's a time during the year when the person tasked with the affirmative action plan has less on their plate. So it might be that's when we want to start the plan, because they're going to have time to gather the information to put the plan together. You can change your plan cycle if you find that your plan cycle is not working for you. Okay, so plans are put in place generally by location. So any location that has over 50 employees would need its own plan. Now, the exception to that rule would be if you applied for a functional affirmative action plan, which in shorthand is called the FAP, F-A-A-P. So that's something you apply for with the OFCCP, and you get approval to do so. If you are approved, then you don't have to have a separate plan for each physical location. But in general, most contractors do have plans for each of their locations that have over 50 employees. Now, for those locations where you have less than 50, you have several options for where you want to include those employees. It's not that they're not covered by any plan. It's just they don't need their own plan unless you want to do it that way. So you could put those employees in a plan, in their own plan that covers that establishment. You could put them in a plan where the personnel function sits that supports that establishment. So by personnel function, the OFCCP means your human resources department. You could also put them in a plan which covers the location of the official to whom they report. So let's say you have plant manager at your small location that has less than 50 employees. If the plant manager reports to vice president who sits at location X across the country, all the people that are in that small location could be rolled into that plan. Okay, now we're going to kind of jump into what I'm referring to here as the new regulations. These are the regulations that apply under VEVRA and Section 503, so they apply to both veterans and individuals with disabilities. The regulations actually went into effect in 2014, March of 2014 to be specific. While they took effect that date, many of the requirements did not begin until the contractor's first affirmative action plan after that date, which for many contractors was January 1 of 15. And then throughout that year, that was referred to as the contractor's transitional affirmative action plan. So there were some requirements that weren't quite in full effect yet. Contractors needed to start tracking information, but they weren't able to report in their affirmative action plan that year on some of the new data requirements because they hadn't tracked the data yet. They needed a year to track that data. So for most contractors, in early 2016, January 2016 is probably the most common date. That's when the regulations took full effect for those contractors. So in audits this year, so this is the first, we're still in the audit cycle, the first audit cycle where the regulations were in full effect. Where the new scheduling letter is in full play. They can ask for everything in the scheduling letter and you're expected to be able to provide it because those regulations have been in full effect. We're seeing a great deal of focus in audits and asking for information related to these new regulations. So I thought it was worth our time to spend looking at what these requirements are. So first up, you have the utilization goal for individuals with disabilities. And so this is sort of similar to the goals that you have been setting in your Women and Minorities Plan. It is, however, a set goal of 7%. It's a national goal, so no matter where you are in the country, you have a 7% goal to employ individuals with disabilities. The test that would apply to evaluate whether you're meeting the goal is the any difference test. You don't have to use like an 80% rule or a standard deviation rule. It's just, is there any difference? This is a goal, it's not a quota. So like under the Women and Minorities regulations, you just strive to meet it, but you don't have to meet it. And there's no per se fine, per se, any other kind of punishment for not meeting that 7% goal. Now I have on the slide just some background for why they picked the 7% goal. There was a survey in 2009 that found that 5.7% of the civilian workforce has a disability. And so they set an aspirational goal for employers to employ 7% of their workforce as individuals with disabilities. Also, do keep in mind that the disability definition under the ADAAA and 503, which 503 was updated to match ADAAA, is much broader than it used to be. And so therefore, the 5.7% probably wasn't, in their opinion anyways, that the OFCCP was not sufficient to capture the amount of individuals with disabilities in the workforce. So they kind of raised the goal up to 7%. Okay, next. What is our organization, what happens if we don't meet the goal? You know, I mentioned there's not going to be any fines or penalties. How the regulations are set up is whether you meet the goal or not, you should be focused on outreach and positive recruitment of individuals with disabilities. And then also that same standard applies to veterans, but right now we're talking about disabilities. But if you don't, you're going to need to even focus even more, and possibly during an audit you may need to focus and provide more information on the outreach and recruitment efforts that your company is taking to try to attract individuals with disabilities and keep those individuals within your organization. Okay, so we'll switch gears and we're going to talk about the hiring benchmark for veterans. So the veteran benchmark is just a hiring benchmark. So in contrast to the utilization goal, which looks at your current employment, the hiring benchmark for veterans looks at your hiring. And there's a national percentage that varies. But right now, as of March of 2016, March 4th of 2016, that's currently set at 6.9%. They do change that goal. I think it might be annually. I think there's been at least 3 different benchmarks set for veterans. And the current one as of March 4th of 16 is 6.9%. So you have the option just to compare, just to look at, just to set a benchmark of 6.9%. Our goal our benchmark is to hire 6.9% of our workforce as veterans. You also have the option to create your own benchmark, and the regulations go through these 5 different factors that I have up here on the slide. You use these different factors and you come up with your own benchmark. And so again, you're just setting that benchmark. Actually, the regulations don't even require you to compare how you're doing compared to that benchmark, but you need to set as a benchmark a number that you're striving to meet for hiring veterans. Okay, next, there were big changes in the regulations in the invitation to self-identify area. So previously, before these regulations went into place, you would never ask anyone, applicant or employee, to self-identify themselves as being an individual with a disability. You might ask, does anyone need a reasonable accommodation, but you wouldn't say, please tell us whether you're an individual with disability. In fact, your lawyers were probably telling you, don't ever ask that question. You don't want to know that information. It's not helpful to you as an employer. But under these new regulations, federal contractors do have an obligation to extend an invitation to self-identify to applicants, to those that are post-job offer, and then also to employees on their status as individuals with disabilities. And you would also ask about veteran status at many of these same points. So for applicants, for individuals with disabilities, there is a set form that you have to use. You can make it a self-fillable form, but the OFCCP has put out a form that they want you to use. And unless you have really good reasons, like to accommodate someone else's disability or something along those lines, they want you to use the same font size and the same type, the same spacing, the same language. So you really should not deviate greatly from that form that they have put out. For veterans, there is not a form like that. There is sample language available in the regulations, but you do not have to use that language. You have a little bit more discretion. But as far as timing is concerned, you would extend that at the applicant stage. So you invite applicants to self-identify their disability and veteran status before you've given a job offer. This invitation can be extended at the same exact time that you are inviting applicants to self-identify their race and gender status. You do it a second time post-offer. So you again extend that invitation. For disability, you extend that same exact invitation again post-offer. Veteran, you can do the same invitation as well. And then for employees, first of all, you need to, if you haven't already, you need to survey all your employees using the same exact form for disability and then the optional form for veterans. You'd want to survey them so that you can identify whether any of your current employees identify themselves as individuals with disabilities so that you can count them toward meeting your utilization goal. And then once you've extended that first year survey, every 5 years thereafter, you would resurvey. And this is for individual with disability status. You do not have, there's no requirement to resurvey for veteran status, but you of course have that option to do so for affirmative action purposes if you choose. Then also for disability status, you have to remind your employees at some point in between that 5-year period, at least once. So you could do it at the 2.5 mark, you could do it at the 2 mark, you could do it at 3 mark, you could do it at the 4 mark. Anywhere in between year 1 and year 5, you need to remind them that they can update their disability status with the company. So I would encourage you to calendar these dates so that you remember to make sure you do that reminder once in the 5-year period, and then again, of course, resurvey at year 5. Now, I've gotten a question from some clients, can we just resend out and resurvey at 2.5 years or at 2 years or 3 years? And yes, you have that option to just resurvey. You also have the option just to send out, let's say, maybe an email that's saying, we invite you to update your disability status with the company if you so choose, and then there'd be a link that they could go and update if they wanted. But you need to give a reminder. So it's either you can resurvey if you want, or you just give a straight reminder. Either is acceptable. Okay. So a little bit more on the self-identify. we have to keep the invitations to self-identify separate from the personnel file. You would keep them in what's called maybe a confidential self-ID file or a data analysis file. All of the invitations, the completed invitations, can be kept in that file, and there needs to be separate security protocols for that file. So, for example, not everyone that could access the personnel file necessarily needs to see the self-identification file. You're going to want to give access to those who are using that information for affirmative action purposes to meet affirmative action objectives. You're not going to want to give it access to someone to that file who is not aware of those objectives and wouldn't be using that information for that purpose. Just like, you know, before these regulations went into place and we said don't ask about disability status, if someone has no good reason to know about disability status, there's no reason that they should know about that. It's not helpful to your organization as an employer. And if they do have access to that information and let's say an adverse action is taken against an employee who happens to be an individual with a disability that's identified as such, that information can be used against the company, and a plaintiff's attorney or the government could use that and argue that the company took that adverse action because the individual has a disability. Now, as I already mentioned on the previous slide, for Section 503 for disabilities, you want to use the OFCCP's form, which is available in PDF and Word on the OFCCP's website. The VEVRA form, there's, you know, as I said, there's not a prescribed form. There is sample language in the regulations that you can use, and that form can be combined with your women and minorities self-identification form as well. There was one slight change for the VEVRA form when the new VETS 4212 report came out. So when we changed over from the VETS 100 to the 4212 report, the 100 report asked employers to identify which veteran category the individual fell into. The 4212 report does not require that. It just has you identify all protected veterans as one group. Therefore, employers have the option of just asking someone to identify whether they are a protected veteran. You don't have to have them identify for you which veteran category they fall in. So that's one slight newer change even since the regulations were issued in 2014. Okay, so what do we do if a person declines to fill out the form? The OFCCP, in its frequently asked questions, has authorized employers and given guidance that you may do a visual. So if you have an employee who has not self-identified, you know, for example, you could do a visual and possibly you might be able to identify their race and probably their gender through a visual. So sometimes you might reach out to the person's manager and ask them to do a visual to give you that information. For disability, you can count someone as an individual with disability if you have actual knowledge that the person has a disability. And I've had some questions, well, let's say, you know, we think they have a disability, you know, should we still count them in our numbers? Of course, we want our numbers to look better, but we also don't want this flipped on us and say, oh, we knew that person had a disability and we didn't do anything about it. You're going to have to do a little bit of a case-by-case analysis. If you have someone who you have actual knowledge they have a disability, you know, they have asked for an accommodation for diabetes, they provided medical documentation that substantiates the fact that they have diabetes, I would say that's actual knowledge, and there would not be any situation where you would be able to argue that the individual is not an individual with disability unless, of course, the information they provided to you is false. So I don't see a downside to including that individual in your count of individuals with disabilities on your utilization analysis. But there might be some situations where you think someone has a disability, but you're not sure, and that might be a situation where you don't count them because that doesn't rise to actual knowledge. Okay. So Another change under the regulations was to the policy requirements that federal contractors have with regard to affirmative action. So we recommend as a best practice that all federal contractors have an affirmative action policy in place. The policy could be combined with an equal opportunity policy, but there is, you want to reference that you have affirmative action at your organization, and you also, under the regulations, there's a requirement that you indicate that the top U.S. executive supports the company's affirmative action program. This policy is also a great place to put that the plan for veterans and individuals with disabilities is available for review and provide hours and location for where that plan might be reviewed. Now, as a reminder, your Women and Minorities Plan is a confidential document, and so you do not have to make that available for review. But the Veterans and Disabilities Plan is different. You do have to make that available for review. Now, there are certain pieces that you do not have to make available, and those relate to the utilization analysis, the company's numbers as it relate to that analysis, and then your veterans benchmark. Those pieces do not have to be made available to employees to review. Okay, reasonable accommodation. We recommend that all employers, and especially federal contractors, put in place a reasonable accommodation policy. That policy will be requested if you are selected for an OFCCP audit, so you want to have that to be able to produce. It's just also a great practice to have that in place so that you have that information out there for your managers who are kind of getting those frontline reasonable accommodation requests frequently, so that they know how that works. Also, you want to be tracking all of the requests for reasonable accommodation that your organization receives and then your organization's response to those requests. In an audit situation, you are asked to produce a log of all of the requests and your responses. And so it's helpful if you've been logging those all along so that you're not having to go back and try to recreate that list. Most of our clients choose, even if the request doesn't come in as a quote-unquote reasonable accommodation, but it seems to be that. Like, for example, Joe Smith requests a special keyboard because he has carpal tunnel syndrome, and the word reasonable accommodation never comes up. And the company, as is routine, they provide the special keyboard. They pass out those all the time. That type of request is still included on the reasonable accommodation list for most of our clients. Okay, so we're going to kind of switch to the EEO clause. So I mentioned this earlier in today's presentation. The EEO clause stands for Equal Employment Opportunity Clause, and there were requirements for this clause in each of the three laws that I mentioned earlier. So under the executive order, under VEVRA, under Section 503, they all have the requirements. And then there's also a National Labor Relations Act requirement that we tend to include in our EEO clause just so it's all in one spot. And so a federal contractor or subcontractor is required to put this EEO clause in a contract. And you only have to do it by reference, so you refer to these regulations. There's one new difference under the new regulations. There is some specific language that is required to be included in your EEO clause in bold. And I have up on the screen two of the OFCCP's approved language for the clause. So you'll note option 2 is the one that includes the veteran and disability reference in bold. That's also incorporated in option 1. But it is expanded. Option 1 is expanded to include the protected categories under the executive order, which are not required to be listed necessarily. There just has to be the referral to the regulations under the executive order, which is up here, this 41 CFR 60-1.4a. Now, neither of these options that the OFCCP has put out on its website address that National Labor Relations Act piece that I mentioned. We have put together some suggested language for an EEO clause that includes that National Labor Relations Act piece. It includes the VEVRA, the executive order, and the Section 503. We've also included language under here to cover the new executive order that prohibits discrimination based on discussion or disclosure of compensation. So you'll see the fifth line up from the bottom. You'll see that we added some language there. I guess it starts on the 6th line up. So so prohibit discrimination against an applicant or employee because such individual inquired about, discussed, or disclosed compensation. So we've added that in as part of our sample language. Okay, another requirement under these regulations is the notification to vendors and subcontractors. So the regulations require written notification to the subcontractors that the company is an affirmative action employer. And this notification is separate from the EEO clause. So you have the clause in your contracts, and then you also give notice to your subcontractors in some separate written communication. There is no timing requirement on this in the regulations related to this requirement, but we have found that the OFCCP expects that you're notifying your subcontractors on a yearly basis that you are a federal contractor. Okay, posting. So federal contractors continue to have posting obligations. The EEO is the law poster, which you should have up under Title VII as well. So there is a supplement to the EEO is the law poster for federal contractors. You want to make sure that's up. We do expect updates to that poster in the near future. So you want to stay on top and make sure you have the most current version of that poster up. You want to make sure it's in a conspicuous place. And if your company is selected for audit and the OFCCP were to come on site, they will be looking around for this poster. So you want to make sure that you have it posted in places that your employees and your applicants can see. So if you have any applicants that come on site to apply, you would want to have the poster in an area that's visible to them. The poster can be electronic. There's a requirement in the regulations that it must be accessible to an individual with disability, and they provide the example of braille or large print or accessible to someone from a wheelchair, so for example at a lower height. The OFCCP has clarified in frequently asked questions that this needs to be available if it's requested as a reasonable accommodation. So you don't necessarily have to have it up there all the time, but you can order a braille or large print poster and put that up. And then certainly if someone requests it and says that, you know, they cannot see the poster, et cetera, you would want to be able to provide that to them in braille or large print, or certainly accessible from a wheelchair, either option. Okay, notification to labor organizations. There is a requirement that if you have a union at your organization, you want to notify the labor organization that you are a federal contractor. Next, data collection analysis. So in order to do your utilization analysis, you have to be able to collect data on who self-identified as individuals with disabilities pre-offer. So these are the different requirements that you're required to track, what I have up here on the slide. Now, one thing I want to point out here is most of these are fairly easy, have been very easy for our clients to put in place. You know, they're doing the self-identify so they can easily track this information for their applicants and hires. The one piece that has been a little bit of a hiccup for some of our clients is tracking the number of openings. So many of our clients will have one requisition with 6 positions tied to it, for example. So they'll have requisition 100 and to hire 6 people, 6 positions. Well, they tracked the number of requisitions there were, but they didn't necessarily track how many openings there were for each requisition. So you need to put in place some sort of system for tracking the number of openings so that you don't have to go back and manually count at the end of the year when you're putting your plan in place. So this is what a sample data collection table would look like. This sample comes straight from the OFCCP. You're required to keep the data for 3 years, which is why we have the 3 columns up here. And so your 3 years of data are kept nice and neat in your sample data collection table. Okay, outreach and recruitment. So I think I've mentioned a couple times that outreach and recruitment are a big focus of these veterans and individuals with disabilities regulations. And in an audit, we're getting lots of questions on this subject. You know, who are you talking to? Who are you working with to try to recruit and attract individuals with disabilities and veterans? I have up here on the slide a list of organizations or contacts that are provided in the regulations. So basically this was taken straight out of both the individuals with disabilities and the veteran regulations as possible resources that you might be able to use. And those regulations are found at 41 CFR 60-300.44F, and then again 41 CFR 60-741.44F. Then also, over here, this is a screenshot of a page on the OFCCP's website. And down here at the bottom, I've got the address here for this page. This page is updated throughout the year, and it also provides some different resources that federal contractors can use to find outreach and recruitment avenues that they can use for their organization. Now, just one little note here on staffing agencies. Staffing, you know, whether you're using independent contractors or maybe a third-party staffing agency is kind of a hot topic right now for many of the different government agencies. And I just wanted to remind everyone that if you're the contractor or you're the subcontractor, you're going to remain liable for the applicant tracking obligations, even if you are using a staffing company to fill your positions. So you're going to have to deal with getting the staffing company to comply with those obligations by contract. If you're the staffing company, you're going to want to deal with, you know, what is your liability? What are you responsible for? Again, through the contract. So it becomes a contracting issue. But you're going to want to touch on that no matter which side of the coin you're on, whether you're the staffing agency or whether you are the federal contractor or subcontractor. Okay, another requirement under these regulations is to do a self-assessment of your outreach. And the OFCCP has provided a form for this. You want to do an assessment for every 12-month period. What's required under the regulation is that it's written and that you're assessing each effort. And you're going to also want to keep these records for 3 years. So we're going to talk about record retention, but there are some pieces that you're required to keep for 3 years, and this is one of them. I have up here on the screen the sample table from the OFCCP on analyzing outreach. And so over here on the left, you'll see that they listed the outreach, they listed the date, they gave a description, and then they do an evaluation for that effort. And they have 2 separate tables. This one happens to be for veterans, and then they have a separate table for individuals with disabilities. Most clients combine this into one table, and they frequently also include women and minority efforts in the same table. Oftentimes they find that their outreach and recruitment effort, you know, goes to multiple protected categories. You know, their single effort goes to multiple categories, and so it makes sense just to conclude it all together. Okay, self-audit and reporting system. So this is another new documentation effort that contractors have to take on. So they have to design a self-audit and reporting system, and luckily the OFCCP has given an example of what they think that should look like. So over here on the left, you list the different requirements under the regulations. So this is just the first two subsections of the 44. So section 44 in both 741 and 300, which 741 is individuals with disabilities and 300 is veterans. Both of those, the affirmative action plan requirements, are located in this subsection 44 here. So then it goes A all the way through K are requirements under this section 44. So you list out each separately, you list what the requirements are under that regulation, and then you're going to go through, again, on an annual basis, you will go through and update, you know, whether you're in compliance or not. And most clients, you know, when they're selected for audit, they go through and they do this yes or no and this remedial actions and follow-up. But you are required to be doing it even when you are not selected for audit. So it's certainly helpful and the best practice to do it on an annual basis. Okay, record retention. So I've mentioned a little bit about that the outreach and recruitment records need to be kept for 3 years. So under the old rule, there was a 1 or 2 year deal. Under the new rule, there still could be a 1, but then it may be extended to 3 years. So there are, for a small company that has less than 150 employees and a smaller contract, so a contract less than 150, you only have a 1-year retention requirement for personnel employment records. Everyone else has a 2-year requirement for personnel and employment record retention if you're a federal contractor. And then there are certain pieces of the affirmative action process that you're required to retain for 3 years. That includes your data analysis, It includes your evaluation of outreach and recruitment efforts, and it also includes records related to the hiring benchmark. Job listings. So under VEVRA, so if you remember, VEVRA only applies to a contract of $150,000 or more. So if you have a contract above $150,000, you have certain job listing requirements. Under the old regulations, this was referred to just kind of lump sum as job posting. The new term is listing. And the difference between listing and posting under these regulations, listing is providing the listing to your local veterans representative in a manner and format such that it's going to be, the job is going to be posted to veterans through those local agencies. So you want to make sure that you're not just logging on to your state or local employment agency and posting the position, because it may not get to veterans first if you're doing that. Now you're going to have to inquire with the applicable state or local employment agency to see how that works, but your questions should be around, how do I get this job listing to veterans first? There was kind of a disconnect, not kind of, there was a disconnect between the OFCCP and these local and state agencies. The OFCCP put these requirements in place, and many of these state and local agencies, at least what we found, didn't have the capacity or the desire to have this extra information that this job listing requirement requires. The key is work with your state or local agency to make sure that you're listing the jobs in a manner that gets to veterans first. And that may vary agency to agency. Okay, training. So you do need to do some training on equal employment opportunity and affirmative action to your employees. We recommend that you incorporate that training into like an annual harassment training that you might be doing already. You want to train your hiring managers, you want to train your recruiters. People involved in the affirmative action process should know what they're required to do for affirmative action. Okay, we're going to kind of jump over to Executive Order 11246, and we're just going to cover some issues and best practices. We're not going to go through all of the plan requirements. So again, 11246 is your Women and Minorities Plan. One of the issues in those plans is how you group your jobs. And really this goes over to the Individuals with Disabilities Plan as well, because you're doing the utilization analysis there by job group. When you do job groups, 10 years ago or more, job groups were getting really large, and there was encouragement to make them large because you can't do a statistical analysis on a small group. Well, it's kind of gone back the other direction. Let's make them small, because under the regulations, you're required to group jobs by similar content, so meaning similar duties and responsibility, similar wage rates, and similar opportunities. We see when the OFCCP does analysis during an audit, they look at your job groups and they compare, for example, how are you paying people within that job group? And so it's great to keep your job group small and making sure that these 3 points are similar for everyone that you keep in your job group, because otherwise you're going to have a wide range of pay, and that may be a basis that the OFCCP might look at your organization for a pay disparity claim. Okay, so availability. So when you do a Women and Minorities Plan, there's a goal setting process. And goals are not a liability area. They could be a basis for more careful scrutiny by the OFCCP in an audit, but they're definitely not an automatic liability. Also, goals. Your affirmative action plan could possibly be discoverable during litigation, and so you have, other reasons other than your affirmative action plan, other than the direct, any direct liability, which doesn't exist for the OFCCP as relates to goals. If it's going to be discoverable, you probably don't want to have a whole bunch of goals in your plan, especially a whole bunch of goals that you're very far off meeting. And so you may want to consider looking at, have we selected the right census code for this job? Or do we need to change the census code? Is there a census code that matches this job better and that possibly might have more favorable numbers for women and minorities? You also want to look at what kind of recruitment area you're using to set your goals. You can give you can create a custom recruitment area for an individual job group. So maybe one job group is 100% national, another one's 100% local, and any range in between. Or maybe it combines several different local areas because you've got smaller locations reporting into this plan that are in different geographic areas. So you create that custom recruitment area. That might better reflect who's in your jobs, and it might, ultimately lower your goals or get rid of your goals. You also want to revisit periodically the weights that you're giving in your goals. So you give a certain amount of weight to external availability and a certain amount to internal. You want to revisit that. You want to revisit the weight among your recruitment areas. And you also want to revisit what feeder job groups you're identifying for that job group. Maybe there aren't any good feeder groups for that job group, so you want to get rid of them. Or maybe there are some great ones and you're doing a lot of internal hiring. You want to identify that feeder group. So you just want to make sure you're revisiting that and not using the same year to year as your organization changes. Okay, adverse impact. This is the area of greatest liability in an audit. There has been much focus in recent years on compensation in an audit, but we're not seeing a lot of liability in that area during an audit. Where we're finding possible liability is where there's an adverse impact based on the hires as compared to your applicant pool. So kind of to break it down, meaning you're hiring, let's say, for example, at a disproportionately high rate of white candidates compared to your applicant pool, which is heavy on minorities or heavy on certain minority groups. If you have adverse impact in your plan, you want to make sure that you're prepared to defend the whole process and how you recruited candidates, how you brought them in, how you screened them, how you picked them, etc. So you're going to want to be able to defend, where did you post that job? Were you reaching out to the right pool? You're going to want to defend on how you reviewed applications, how you did a background check, a self-ID form. You're really going to want to go through this whole process. You're also going to want to be able to say which stage did the applicant fall out at. You want to be able to defend your selection by saying that the reason they were screened out, it was job related, and that you consistently apply those criteria to all of your different applicants. Now, a few tips. So you want to make sure you're running adverse impact ratios yourself on an annual basis. You want to be running your adverse impact. That's not a part that you put into your plan itself, but you want to be running those analyses to see if you have problems so that you can possibly correct those problems before an audit. You also, of course, the OFCCP is going to run this analysis when they audit you. So you want to be doing it, if you are selected for audit, you want to make sure you've done it so that you can know going in where are our problem areas so that you can be getting records ready and be able to defend selection decisions in those job groups where there are problems. So the key is documentation. So oftentimes employers have good documentation for why someone was terminated and why someone was promoted, but they don't always maintain the best documentation for why someone was not hired. We can say, we know why we hired Sue Jones, but we have a hard time pinpointing exactly why we didn't hire all these other 150 candidates here. We just didn't keep very good records on that. And it's important that you do keep good records. So to do that, you want to use disposition codes that provide reasons for why certain applicants were not hired. I have up here on the screen the definition of applicant. And the reason I've put that definition up is because it really is a narrow definition. And if you can get someone to fall out of the definition of applicant, they wouldn't be held against you in an adverse impact analysis. They would be removed from the analysis. So the key is if the person does not meet the basic qualifications for the position, we need to document that and how we knew that. So if it was we reviewed their resume and they didn't meet the basic qualifications, we want to know that. Also, we want to know if the person ever removed themselves from consideration. So let's say they took another job and they told you they're no longer interested. They've removed themselves from consideration when we want to document that and how they removed themselves. Let's say it's just they never called us back. We called them and tried to schedule an interview and they didn't call us back. We want to know that because, again, they've removed themselves from consideration, so they're no longer considered to be an applicant. So defensive disposition codes, I have up here some examples. We know that they they were at the drug test stage and they didn't show up for it. If they didn't show up and take the drug test, we couldn't hire them, so that's why they fell out of the pool. I have some other examples up there. Okay, so general applicant tracking tips. Assign a requisition number to each requisition so that you can tie applicants to that requisition. Require applicants to apply for a single open position. Don't just let them turn in their application and you're going to consider it wherever, because then they're considered an applicant in all these different positions, assuming they're qualified and you have those openings. Don't accept unsolicited resumes or applications. That's one idea. I know that that does not work for all organizations, but it may be something to consider, especially if you're finding that you're not getting qualified candidates by accepting the unsolicited resumes or applications. Include in your applicant list those that are internal candidates and external. You're going to want to think about who has access to your applicant log and whether they have the proper training to enter the proper disposition codes. You're going to want to check your disposition codes from time to time and see how they're being entered and seeing if they're used consistently by each of your different recruiters that do have access to it. We're going to keep moving. We're getting a little short on time here. So pre-employment tests, just note that these are disfavored. You're going to want to track whether you're screening out people on their gender, race, or ethnicity, because the OFCCP may look at that. Compensation analysis. This is a hot area. We've got the new EEO1 report where you're going to be reporting compensation, and during an audit, you provide all of your compensation for every individual employee at the establishment that's been audited. So you may want to think about looking at compensation and doing a study to see how your compensation looks and whether there are disparities in it. Okay, we're going to kind of breeze through a couple of the new executive orders and changes that are outside these three laws that we just covered. Okay, so I mentioned we have the new EEO1 report. The deadline to submit that report is not going to be until March of 2018, so there will be no deadline to submit an EEO1 report in all of 2017. As of March of 18, you'll submit the data from 2017. So at some point between October and December of 2017, you will pull your employee snapshot. Then at the end of the year, you will add W-2 wages to that snapshot that you pulled, and you will report that information by pay bands by March of 2018. Disclosure of compensation information. I mentioned this earlier. So there was an executive order that prohibits discrimination against someone who has discussed or disclosed their compensation. There is an exception to this if they're, for example, a human resources personnel who has access to everyone's compensation and they're disclosing everyone's compensation or other people's compensation based on their access that they have. That would be different. But someone is free to discuss their compensation. This would include management employees, unlike under the National Labor Relations Act, which excludes management. This order is now in full effect. Well, assuming you had a new contract or a modification of an existing contract after January 11th of this year. But it's been a while now, so if you're still a federal contractor, there's a good chance that this order is in full effect for you. Two changes that you have to do in order to comply with this is update your Equal Employment Opportunity Clause, and then you add what's called a pay transparency statement to your handbook. I have the language up here. This is mandated language under the executive order. You're going to want to make sure that this statement goes into your handbook. Sexual orientation and gender identity. So that's been in effect now for a little bit. So April 8th of 2015 is when it became effective. There are several little changes that you're going to need to make sure you're protecting these categories, modifying your EEO clause, modifying the narrative of your affirmative action plan. We expect there'll be a new EEO as the law poster. You may need to update your tagline in job advertisements. You need to make sure that spouse benefits are being offered where appropriate. And then finally, we have this Fair Pay, well, no, I have one more after this, Fair Pay and Safe Workplaces Act, which is currently kind of, I want to say tabled is the right word. Parts of it anyways have been tabled. There was a decision in Texas to enjoin this order for So a preliminary injunction is in place that stops certain portions of this law. So what it requires is federal contractors to disclose what's called merit determinations, violations of different employment laws. And I have up here kind of a list of some of those laws. The list is actually much longer. This is just a sampling. So let's say you get a probable cause determination out of an EEOC charge under Title VII. You'd have to disclose that as part of your application for a federal contract. So obviously this is disfavored by many federal contractors, but this piece is currently enjoined. There is this second piece. This piece is not enjoined. So there, you have to give a statement to your employees with your hours worked, your overtime, and your pay. I think probably most employers are already doing this, but you need to be sure that you are doing this. And if they're an independent contractor, their documentation should note that they are an independent contractor. Finally, there's a piece that you cannot you cannot require arbitration, or the employee can't consent to arbitration anyways until after the dispute arises. This piece is also enjoined currently. And then paid sick leave. So this is just going into effect in January 1. So if you have a new federal contract on or new or modified federal contract on or after January 1, you have to provide paid sick leave at this rate. They have to be allowed to carry over up to 56 hours. You can put in place a cap on how many hours they can accumulate, though. So, you know, let's say they have 40 hours left at the end of the year. They carry over their 40, and they keep accruing time, and they haven't taken any of their sick leave. Once they get to 56, you could stop them. If the person is terminated, you do not have to pay out any accrued leave under this, that's accrued under this law. So that 56 hours does not need to be paid out. Okay, kind of wrap up some best practices. You know, number one is educate yourselves, which you're doing that today. So that's you're doing step one. You're going to want to look at your current affirmative action plan and be asking questions to make sure you've got the right things in place, so that if you're audited, you're not scrambling to get those things in place. When you're audited, you have 30 days to turn everything over, which passes in the blink of an eye. So you want to make sure you have things in place. You want to make sure these new data requirements, the self-audit table and the assessment of outreach, are in place. You want to make sure you have quality data. You make sure you're tracking your applicants. Bad data in equals bad plan out. So you want to make sure that your data is in order, because that really is going to affect your numbers that you have in your plan. You may need to be doing some reviewing and revising of policies. You certainly want to be educating your hiring managers and your recruiters that are involved in the hiring process. Any personnel involved in the hiring process, make sure they're up to speed on what are the affirmative action requirements and what do we need to do at our organization. You also want to be giving reports to top management on the status of affirmative action. That will be another thing that's asked for during an audit. And finally, it's adding training during your new hire orientation and for your employees throughout the year. And with that, I have gone through all my slides. It looks like we're a little bit over on time already, but if we have any quick questions, as long as Eric says it's okay, I can take a couple questions.
Yeah, I'd say if you're fine with it, Erin, we can do a couple questions. There were a couple that came in. I think I sent them to you in the chat.
All right, so I see one question. So if we don't have an ATS, so if we don't have an applicant tracking system, do we need to collect this data on applicants? So it looks like, and this is a small company with a total of 48 to 51 employees. So if you don't have the affirmative action plan requirement, so you haven't hit that 50 employee threshold, then you don't have to be tracking. But once you hit that 50 employee threshold, you do need to track, even if you don't have an applicant tracking system. How a small employer might do that is they might use like an Excel spreadsheet to track their applicants. So another question that we have here is, when we say train on an affirmative action plan and orientation, what are we training them to know about? We just want to make sure they know that the company is an affirmative action employer, make sure that they know where to go should they have a question about it. You're going to want to cover the affirmative action policy, which, as I mentioned, would state in it where an affirmative action plan might be reviewed should the employee want it. Again, during an audit, you'll be providing records of this training that you provided. And so it's just one more, you can check the box off during the audit. The compliance officer could, say, hey, look, they're doing this. And so when you have a lot of good things that you're doing, the audit tends to go a little bit smoother. Maybe they don't dive as deep during the audit because you've got all these boxes checked off, you're doing all these great things. And so it's just one more step. Let's see if we have any more questions.
I think there was one other